record it 2 different ways just in case. And okay, so welcome to our session on trademark and copyright crash course. It's really about safeguarding your brand and your intellectual property. The first thing I wanted to go over real quickly is the difference between a trademark and a copyright. So a trademark would be your name, like Coca-Cola or Nike. And a copyright is something like a book or a film, a piece of artwork, other creative works. So sometimes people even submit for copyright their marketing material, and that's perfectly fine. You submit that to the Copyright Office, and then that registers it. So I tend to tell my clients, if it's going to be a page that you want to have protected, then that's a copyright. It's a creative idea. Now, one thing that I do want to make sure everybody knows is you cannot copyright something generated from an AI. It's an AI. It's not an option. It's not creative. A person did not do it. So I know everybody's starting to use a lot of AI tools now. Just be aware that AI created creative works, whether it's copyright or trademark, are not copyrightable. For the trademarks, if you're using things like Canva to create it, it also may not be able to be trademarked as a logo because you're using the Canva elements or photos. So if you look in their terms and conditions, they'll have some exclusions for use. So I'm just going to put that as a caveat since most people are not aware about those things. And I want to make sure that everybody has a much firmer grasp of what they can use. So when you're developing your business, doing so with a purpose or understanding what the limitations may be at the moment. Now, in terms of creating a trademark, those are the names, the slogans, the just do it, the smells. Some stores have certain smells that are unique to them, or the sounds. So the NBC chimes, those are all trademarked. And the key for the trademarks now is to be aware of what you're trying to mark. One of the issues with trademarks is something might be able to be trademarked as a logo, but not as a word. So my firm name is a prime example of that. I cannot claim my last name because other people have that last name. That wouldn't be fair. So I cannot have a trademark for the word Nazaro. I can trademark my design. So this logo that you see, that is trademarkable because I'm not claiming that the word itself is just for me. I'm claiming the design style. There are other companies out there that incorporate the word Nazaro, and that's just tough luck for me and tough luck for them. So that's one thing to be aware of when you are creating a name. Is certain things you cannot use. You can't use something that's generically used for your industry. What you do want to think about is, can I use a made-up word? Those are so much easier. Can I use something that's not related? So a really good example of this is apple. An apple is a piece of fruit. I can't trademark the word apple for fruit, but you can use the apple for a computer or computer software and systems because they don't really fit. You're using something for a new distinctive purpose, and so that's going to get through the USPTO. You're really looking for a trademark to be identifiable and relate between one service or product and then that mark, whether it's a visual or a word. So when I say Nike, immediately you're going to think athletic wear, shoes, apparel. So that mark is linked, and that's what you want to do for your business and for your services and goods. Does anybody have any questions on these two terms? Because people have used them interchangeably, and I just want to make sure everybody's using the correct term when they're looking to protect their IP. And by the way, copyright is much cheaper to get than a trademark. People copyright a lot of things. Everything has a common law copyright protection, but when you register it, you have additional protections at your disposal if you ever need to use them. And I'm not going to talk too much more about copywriting. It's a relatively straightforward process. I just want to make sure everybody knew which one was which. Okay. if you have a question, please come off of mute. I'm going to look at the chat real quickly. So for creative projects, books, scripts that are ongoing, so maybe just one version get to be submitted, I would submit the final. I mean, finish what you're doing and then submit it. You can always submit again, but I mean, it's going to add up a lot. For trademark, if you do have a unique name, can you go for the name and then that will cover all future design derivatives? No. So let's say that Nazaro was not my last name, it was a made up name. I can trademark the word Nazaro, but I can't claim all design features that use the word Nazaro if they're used in a different way. And there's even where you can have a company name that's for athletic gear. So let's say there's Nike for athletic gear. And there's another Nike that was developed independently. Let's say Nike wasn't as big as it is now, that sells guitar strings. There's no chance of confusion between guitar string sales and athletic wear. So you're only reserving the right for your area of goods and services. Does that make sense? Okay. Feel free to talk. It's okay if I'm not doing all the talking. The next part here is different types of marks. So we have, as I was saying, the standard mark, which is the word. So it's going to be Nike or Adidas, which by the way is a made up word. It's going to be Apple. The design mark is the picture, the graphic, the visual. So when we describe this, we would say I don't know if it's quite a silhouette. I'm at loss for adjectives, but a picture of a jaguar cat leaping from one side to the other with the back paws down over the word jaguar in all capital letters. And there's different ways that we can present it. Is it going to be black and white? Is it going to be with color? Black and white is going to provide you with more generalized protection to a certain degree versus having colors means that there's going to be the exact colors that are protected for that. And there's different reasons why you would do each one. But that's part of the reason why you get an attorney is to help you work through what is it you're trying to protect and what are you worried about in terms of infringement and how enforceable is this going to be depending on which path you choose. A lot of trademarks are submitted without color so that you can use black or white or purple as long as you have that same overall design. Anybody have any questions? I see something in the chat.
So Mia, this is a design mark for Jaguar, not a standard mark because you can't trademark the word Jaguar.
No, you can trademark the word jaguar for something that's not a cat. So the word itself of jaguar could be trademarked because it's used for a car. So a car called turtle, that's true. They're not related. A turtle's not a type of car. It's not a type of vehicle. So you're using a commonly used word to describe something that it's not normally associated with. And I will tell you, finding a trademark word is not easy. Everybody on this call has probably tried. It's a lot of work. You have to find a domain name that's available because that gives you an idea if somebody else is using it. You have to find something that's going to resonate with your audience, that they can pronounce, that they can remember to spell, right? So they can get to your website, something that nobody else is using. It's really hard, especially if you're not a huge creative type. How do you make a made up word that's going to catch on? So Adidas is a made up word. You can't trademark something. If I was trying to sell a car and I called the car coche, which in Spanish is car, that would not be trademarkable because it actually means car. Just because it's in another language doesn't exempt you from using a generic term to describe a specific product. You can't take over that domain. Does that make sense?
Yep.
We're going to get to the budget in just a minute towards the end. Okay. So there's two types of protection for trademarks. One is common law, and one is if it's registered with the USPTO at a federal level. So the common law protections are much more limited. You're only protected in the geography of use. So if you're only using it in one town in Texas, then that is the area where it will be protected. If you're using it across the state of Texas, then it's in Texas. The federal one, if you register it, then you are granted use of that throughout the country as long as no one else has used it before in a particular geographic area. And I'll give you an example. Under common law, you have very limited damages that you can petition the court for, and it's protected by state law. If you go for the registered route, so you go to the USPTO and you register your trademark, you are declaring an intent to everybody that you want to claim the trademark across the United States. You have a better ability to sue for damages, and you have access to more damages. Now, the caveat to this is, are you going to sue somebody if they infringe on your trademark versus pushing in a cease and desist letter? So always keep in mind, what are you actually going to be doing with this? But it does afford you so many greater protections. You can use a symbol with the R in it. You do that, then everybody is on notice that that is a registered trademark across the country, and then they should not be using it. A common misconception is if I trademark my name and somebody else has been using it, that I can push them out of business. And that's not the case. And one of the best examples is Burger King. So Burger King is all over the country. Everybody knows Burger King. We all know its logo. We all associate Burger King with burgers. Done. Fast food, right? Well, there is another Burger King that existed before this franchise exploded and registered the trademark. That Burger King is located in one town. They sell burgers and they get to keep their name because they were there first. So they have common law protection in their geography. Now they can't expand, and it's one little town, but Big Burger King, National Burger King, is not in that town because they cannot compete using that same name. And sometimes you'll see companies that use a different name in some states, and that's because that state already has a prior user at a common law level. And so you can see how having a registered trademark can provide you with much more protection, and it excludes your competition from coming in other places. So you have the opportunity to expand. It increases the value of your brand. And that's what I wanted to talk about, is that trademarks is part of your intellectual property, which can be a source of value to your business. So your trademark is only as valuable as the goodwill that's part of it. If nobody knows that Nazaro is a law firm or cares, then my value is much less than, say, I'm going to a Baker and McKenzie. Everybody knows Baker and McKenzie law firm, right? So the value of their trademark is much higher than mine. Well, I like to think important. I know I am not. So if you can compare the two, you can see which one has more value. But value is based on building that over time, creating that name recognition so that when you are looking for an exit strategy, you have more value that you can peg because it's more than just what you can count, right? And it's really important to know that when you're filing, you submit your application. It's about 14 to 18 months until you hopefully get it registered. And you're first in line for protection if you've been using that mark. So you don't want to wait. You want to do it earlier, because if somebody else starts to use it during that meantime, or they file, trump your rights at a national level. You do have people who are squatters, so you do want to look and see, has anybody registered this name and they're doing some business. But you also want to have good brand recognition. You don't want to have confusion between your brand and another. You want it to be distinct. And you want to preserve the value that your brand is bringing to the table. You're going to be working to build this business, and the business is associated with that brand. If you have to rebrand, that's going to be expensive. Why not change your brand now you get to that point? And you also want to be able to expand, right? You don't want to be just stuck in a tiny little bubble. You want to be able to grow. And what does growing mean? What's your ability to franchise? What's your ability to bring in investors? So if you have a value in your brand, you're suddenly going to be in a different echelon of companies to consider. And again, if you have any questions, please let me know because I am not able to see the chat very easily on my screen. So there are two keys that most people are not aware of when they file for trademarks. And this is what really stumps people. So you need to show that you're using your mark and that you're using it in interstate commerce. Remember, the federal government can only govern interstate commerce, commerce between countries. So if it's just intrastate, let's say you're selling these cups, my lovely cup. Oh, there you go. But I only sell it in one state in which the company is operating. That's not interstate commerce. So you want to sell it, you want to ship it or render services across state lines. That's interstate commerce or internationally. Okay. And so the use of the mark, if I was only doing interstate commerce, or if I was only a state within one state commerce for a while, that would be my first use. The moment I do interstate commerce is going to be another key time because now I'm eligible to file for a trademark. You have to actually use in real life. You can't just use mock-ups. They want to see that you're actually using it, whether it's for good or services. Services can be on a website. You need to show that that mark is used in correlation with that goods or services. So it can't just be your mark on a big website and that's it. What do you do? What is it that you sell? That's what they're looking for so that they're related. And you also want to look and see, are you actually using it or are you nominally using it? So if you've only sold it once and it's something that should be sold more often, it's not, the biggest diamond in the world, then you want to make sure that you're showing that you are developing that business. The USPTO is trying to give trademarks to businesses that are actively using a mark. So you need to actively be doing business. This is a huge trip for many applicants. This is a big source of pushback from USPTO on their options when they're reviewing your mark, and they're going to ask you questions about this. So this is a really important part to pay attention to. This is really where the value add of an attorney comes in, and then there's one other area as well. The rest of the questions you could probably get on your own. So that brings us to why hire an attorney. Whether you hire me or somebody else, there's a couple of other chief women here who do intellectual property protection. You should. It's a government form. Government forms are horrible. You don't understand them. They're referencing information that you're not familiar with. And if you mess up, you get to start all over again. And so hiring an attorney can be worth the upfront investment so that you're a better chance of getting through the process. You need to actually identify for your mark what it is that you're using the mark for. So there's a classification system. You have to identify by number which class you're going to be using and describe it. If you do not describe it properly, it may be rejected or you may not have the protection that you actually wanted. So you want to make sure that you're putting forth the correct descriptions in the way that the USPTO needs to see them. And the classifications go from easy if your business is selling food to much more complex if you're starting to get into computer systems, app-based programs, a website, and downloadable content. There's all different types of classifications that you're looking at. So having somebody that can walk you through that to make those decisions is very helpful. Attorneys also can do additional searches. So we offer a basic search for our clients unless they would like to pay the additional fee to do a very robust search. Because usually we're able to pick up on a lot of issues on that very basic search. And so we have our own process of reviewing the USPTO system and looking online to see if your mark is being used elsewhere. And then we let you know, hey, an issue. How do you want to proceed? This is what the issue is. This is the risk. Are you up for moving forward? Do you want to change the brand? Do you want to change strategy? This is what we think might be some of the pushback that you get from the USPTO. And that's up to each individual client what their risk is. A little bit about me. I am a chief member for almost 2 years. And I am very, very passionate about working with entrepreneurs and helping them find the solid foundation to their business. I am a professional enabler because I enjoy watching other people's visions come to life. It is fun. And I also enjoy having the conversations of what it is that you are trying to accomplish so we can do so in the most effective way possible. So we're meeting your personal vision and your professional vision as readily as we can. And then see here. I wanted to go over, somebody asked about cost, and I'm going to go ahead and have my colleague post my LinkedIn information and some links as well. We are offering a program. I had put that into our announcement. I listened to a lot of chief members who talked about how expensive it was to get legal help. And I don't want that to be standing in the way of people. So we rethought our own process and started to rethink how we offer our legal services. So we're going to do a pilot program. We're offering cheap early bird specials. So if you sign up by Black Friday, which is next Friday, we're going to do in particular a trademark intensive class where we do a group consultation and we provide you with information you need to know, how to fill our intake questionnaire, what we're looking for, things to consider. So you're getting the really in-depth legal counsel that we would give every one of our clients, but in a group format. We're creating a hub as well, which is a community of people that are going through the program. So you can talk to each other and you can help each other grow each other's businesses. You can share resources. Chief is successful because we work together. We work together because we have common interests. And so I want to take that concept and pull it into the law firm so that while that part is not protected under attorney-client privilege, it's about community, it's about growth. What we want is for our clients to grow and to have stable foundations, not just legally, but from a relationship perspective, people that they can to and ask for contacts, ask for advice, ask for referrals. We're going to include in this the ability to make 2 trademark applications. So most of our clients do their standard mark and a design. Sometimes they have 2 standard marks. Sometimes they have a standard mark and a tagline. So you can choose what you want your 2 to be, but this will give you 2 trademark applications for 1 class each. It does not include the filing fees. Right now, they're $250 for each trademark for 1 class. But we want to be able to work with you to protect your business as much as possible. Our group session will be held on Thursday, November 30th from 2:30 Eastern Time or 11:30 Pacific. And during that time, we'll go through the legal counsel. The video will be available for 1 week after for people who have signed up for this seminar. And we encourage you to take advantage of this. The regular price for the intensive is going to be $1,700. And if you were to do it on your own in the traditional law firm format, we typically do a fixed fee on this. It would be $950 each, which is $1,900 for 2. So as you can see, it's a pretty steep discount. And we're hoping that this allows more people to apply for the trademarks that they are looking for and get the protection that they're wanting. If you go to our website, you can see that we've just launched this pilot program. There's Express Legal Hub Intensives. Please excuse any typos because I've been doing this at about midnight for the last few weeks. But this is a new way of providing legal services, and we want to try it because the old way doesn't always work. So we're going to work on accelerated business formation. We're going to leverage group meetings and group support as a community. We're still going to provide the customized legal documentation that's covered under attorney-client privilege and have one-on-one consultations as may be needed or email communication that is provided, that is protected under attorney-client privilege. And we want to make sure that you get the trademark protection you need, that you get the documentation you need. We have 2 programs that we're also launching. One is the New Venture Basic Program to form the company and be ready to go online. And that's over a 4-month process. We are offering a special to chief members who sign up early. It's $550 a month instead of $675, and it's a total of $2,200. So again, trying to offer that steep discount. The accelerated venture is for those who are looking to add a board of advisors and who are also looking to do this much more rapidly. So we're going to get everything done in 2 months. It's going to require some commitment from participants to get us the information they need, but we're going to walk you through that. And the accelerated venture on the chief discount is $22.50. And I'll put this in the discussion for this group on chief so you can refer to it. I could not figure out how to do the strikeouts on this thing, and finally I just gave up. So I will communicate it to you through the chief forum. And as you can see, here are the dates that we're going to hold the sessions. Again, if you can't that date, that's okay. We will record the sessions and you can access it for a week, up to a week later, and submit all your materials. And then we also offer these add-ons and the consulting early bird discount. So if you need a consulting agreement, it's going to be $14.40. The multi-member council, if you're forming a company with another person, which we highly recommend you do this one, is only $700 for the special for chief. And the reason why I suggest this is because a multi-member LLC is much more complicated. And then if you're looking to do new hires, you're looking to bring on 1099s or employees, then we have a special package for that. And the chief price on that is $37.50. And so what we have done is taken the most common elements that our clients use. We have reworked our own workflow, and we hope that this enables everybody to access services at a lower price point, but still retain all of the value that we normally provide our clients and as a community. So I hope that this is of interest to some of you. It's on nazaralaw.com/intensives. And I wanted to say thank you. If you don't mind, I'm going to have my associate, if she hasn't already, post our LinkedIn page. Please follow us for more information. We're going to start posting our blogs about legal topics. We are also thankful if you are able to post a Google review. It means a lot to me as a small business owner because it's hard for clients to always give reviews since they don't necessarily want other people to know that they had to use an attorney. So if you could give us a Google review, I'd greatly appreciate it. And if you have any questions, I'm more than happy to answer it. I can stay on the line for a little while longer, but I know everybody has a busy day as well, so I want to be respectful of your time.
Hey, thank you, Maya. Calling from Oceanside. This answered a lot of my questions. I really appreciate your time.
Oh, good. I'm so glad. Thank you, Joan.
How to make a Google review, but I put down how to figure that out.
Okay, well, thank you.
Hey,
Bye-bye.
Bye.
happy to Google review if you can post the link so it's easy for us to get to it, and then
Yes.
happy to do it.
It should just have been, it's right in there. If you look in the chat box, it should be in there.
Okay, cool.
Thank you. Does anybody else have any other questions?
Yeah, I have a question about, and first, thank you for your presentation. It was very efficient, and looking forward to doing your review as well.
Thank you.
Question about the multi-state formation. So it looks like your firm is in Washington State. If you want to
Yes.
in another state,
We can do that.
you can do that still.
Yes. So I didn't on the call, but I hold multiple licenses, and on our team, we hold additional licenses from other team members, and then we work with a consortium of law firm partners as well. So we can reach into most of the states where people are located in chief. So we're in California, Texas, Washington, New York, Florida, DC, Maryland. I might be missing some, but we have another law firm that we're also with a consortium member with, and they cover basically all of the Midwest, what I consider the Midwest. So the whole central part of the United States. So we can almost anywhere we want, and we work with a third-party service to also do some of the filings. So there's different ways that we can manage the process.
Okay, cool. That was my question. Thank you.
Absolutely. Any other questions? Okay, well, I will let you all go. I really appreciate you being here, and I wish you the very best of luck on your business ventures. Thank you.